Hey, welcome to Tallgrass Snacks. What are we snacking on today? Really common question we get asked, what's the difference between a power of attorney and a guardianship? Why is one preferable over the other? We're going to give a quick primer on that difference. So let's start with the basics and just define our terms. What's a power of attorney? A power of attorney is a legal document where you give someone else the authority to be you, essentially. Whatever that power of attorney is dealing with, if it's financial or medical, if it's broad or limited, you're essentially saying whatever I could do legally in that arena, this person can do legally in that arena. Whatever I can do, they can do. They can open and close bank accounts, buy and sell real estate, talk to my doctors, give informed consent for an operation. My power of attorney can do those things. So what's a guardianship? Well, a guardianship is very similar, except that in a guardianship, it's the court that's granting someone that authority instead of you granting someone that authority. Whatever you could have done if you'd had the capacity to do it, your guardian can do if they've asked the court for that specific authority. So they sound really similar. They end up having a very similar result. Powers of attorney and guardians can end up doing very similar things. So what's the difference? What's the advantage of doing one over the other? Well, the primary differences break down into three categories: cost, time, and challenge. There's a difference in how expensive they are to create. There's a difference in how much time they take to create, and there's a difference in how easy they are to challenge. A power of attorney is a much less expensive prospect than a guardianship. In some cases, it's free. Download the statutory power of attorney, or get on LegalZoom, or go see an attorney to create a custom document. But compared to a guardianship, that's going to be a very cheap endeavor. Powers of attorney are much more quick to create, same day. It occurs to you to create a power of attorney, it's done. Whereas a guardianship in Oklahoma can take at least a month to get through the process necessary to appoint a general guardian. And power of attorney is much more difficult to challenge. Assuming you've got two unrelated witnesses and a notary who can have witnessed and can testify to the fact that you had capacity to sign that document, nobody can challenge it. You can appoint whoever you want to be your agent. In a guardianship, the whole thing is designed to be challenged. We want people that are part of your life to be able to come to the court and say to the judge that you do or do not need a guardian, that the person who's petitioned to become your guardian is or is not a fit and proper person to play that role. So the thing is designed to be challenged. Power of attorney, inexpensive, quick, hard to challenge. Guardianship has the same result, but in order to get there, it's much more expensive, takes more time, and is intended to be challenged. If you do nothing else in an estate plan initially, no will, no trust, nothing, at least get yourself a power of attorney. It's going to save yourself and your loved ones a lot of time and heartache and money compared to having to sort of default to the guardianship process. Hope that has been helpful. Leave us some comments, subscribe, ask if there's something you want to know about.